My name's Catherine Dixon. I'm the Director General of the Chartered Institute of Arbitrators, CIArb. My professional background is that I'm a solicitor. I'm also an accredited mediator. Been with CIArb since May 2020, so just after lockdown, and it's really great to be invited to speak with you all this evening. I'm going to do a little bit of scene setting about the subject, and then I'm really going to hand over to our experts, to Isabel Phillips and to Jane Gunn, who are going to speak both as practitioners and also sort of experts, particularly around some of the international dimensions and the impact on, or potential impact of mandating mediation in England and Wales. So, but just by way of background, I mean, I suppose the starting point for this is just sort of thinking about where we are with our justice system, and the fact that we recognise that we've got court systems which are overloaded. The pandemic has clearly had a negative impact too, and we also know that there's a concern about access to justice and unmet legal need, and we've talked about that for many years now. And what seems to be happening is that we're seeing an increasing sort of amount of rhetoric and recognition that ADR could be one of the solutions to this. And we've heard that recently and consistently from Geoffrey Voss, who's the, I would call him the new master of the rolls. He's been around for a little while now, but certainly he is a big proponent of ADR. So what we saw in June 2021 was a Cjc report on compulsory ADR, and it addressed two issues. So first of all, this core issue, which is a legal block on enabling or promoting enabling sort of mediation to happen in a kind of a compulsory way, and also a question of desirability. So if you read the report, the legality question, the report effectively concluded that parties can lawfully be compelled to participate in ADR. And I'll talk a little bit about the current position of the law on that, but that's effectively what the report said. And the report also said that it was desirable. So it looked at conditions in which compulsion to go down an ADR route is actually desirable. So put in very simple terms, it was a kind of clear statement that if the court orders parties to engage in ADR, this issue around that impeding on human rights is not an issue. So before there was a case that some of you will be familiar with, the case of Halsey and Milton Keynes NHS Trust. It's a 2004 case, and what happened there was that the court sort of decided that it was looking at the issue of costs, and basically it sort of considered whether a successful party who refused to agree to ADR could be deprived of costs, and the court effectively said that it would be an infringement of Article 6 of the European Charter of Human Rights in the event that happened. And this has been sort of seen really as a legal blocker to compulsory mediation. So though the Cjc report doesn't set aside that case, what it's clearly stating is that actually this legality question should fall away, and therefore it's kind of seeking to pave the way for mandated ADR or particularly mediation. So on the back of that report, the Ministry of Justice issued a sort of call for evidence, and the call for evidence was, it didn't actually refer to sort of mandated mediation, but it was quite clear that that's really what it was trying to get at. And the purpose of tonight is really to sort of talk about some of the issues that flow from that. We've responded in terms of CIArb, we've responded to that call for evidence. It's got 33 questions. Some of them are, were a little bit kind of left field, but we took the opportunity to really sort of go out to our membership globally and look at what's happening elsewhere in other jurisdictions, and really use the opportunity to try and sort of inform this debate. And so, certainly Isabel, who was very much involved in speaking to people, mediators around the world, will give you a bit of insight on that. But I think the core issues sort of coming from CIArb's perspective is, we want to obviously encourage and enable the take-up of mediation. And whilst mandatory mediation is kind of one tool in the toolkit, it's not an end in itself. And there's a number of things that really need to be put in place to enable this to happen effectively. And to a certain extent, the Cjc report assists with this sort of endeavour of sort of encouraging and enabling mediation, as by sort of effectively legitimising the mandatory nature of it. But there's also some sort of downsides with the report. It also provides so one of the concerns is certainly when we get into the issue of costs, and the other concern surrounds a sort of a recommendation of sort of judge-led mediation, which if you think about where we are, if this is truly sort of enabling people to access justice, given where we are with the courts, going down a sort of a judge-led process, given the burden on the court is not necessarily, certainly from our perspective, would be the preferred option. So there's a few things that came out of the report which potentially were problematic. So what we've effectively said is that there's kind of, mandatory mediation, yes, but there's a few things that need to be in place. So to effectively use and promote complementarity of different DR processes, then there's no one size fits all. So one of the things that the call for evidence was focusing on is whether there is a preferred stage in which you go to mediation, and we're effectively saying, actually, the whole beauty of mediation and alternative dispute resolution processes is that there is flexibility, and that the parties, have that right to choose how best to proceed, and therefore mandating a particular rigid process for mediation at a particular stage in the proceedings, could be problematic. And actually, when we look at the evidence from around the world, you will see that where there is mandation, it's not necessarily just at one stage that everybody sort of said, well, you've got to do it here or you've got to do it there. It's actually multiple stages in the proceedings. So there's something that needs to be addressed in relation to that and how that would work. I think the second area is in relation to costs, and clearly a poorly designed and poorly funded mandatory ADR process could actually do more harm than good. And so there is some, certainly there's one interpretation of some of the findings of the Cjc report is that, actually this is a cheaper option. And obviously, it needs to be properly funded, and it needs to be sort of thought through in order for it to work effectively. And it's not that people are going to be in a position to do sort of a pro bono mediation as part of a court process, and we'd be strongly opposed to that. So we've made it clear that that any process needs to be fully funded and properly funded for it to be effective. If not, it really does run the risk of harm, because we need to make sure that that mediation is being used effectively and people are appropriately trained and operating to appropriate standards. And I think the third area which we think is really important to sort of enable this to happen effectively, is that there needs to be more sort of public education and business education promoting the benefits of ADR, because there's still a lack of knowledge out there about the benefits of using ADR, including mediation, in the process, and therefore it needs to be incentivized, promoted to the business community and to other users, so that there's a better understanding of the benefits of using ADR, which currently, and obviously CIArb is very much engaged in that process. One of our strategic aims is to raise the profile of ADR and its use, and we are engaging regularly with business about it. But I do think it needs to, we do need the support of government to enable that if they're serious in terms of introducing this as a mandated process. So those are some of the things that we've been grappling with, and our response has been shared. It's available to members. I think it's probably on our website. We'll probably find a link or something to it. And do, if you've got some time, do take the time to sort of have a read of what we've submitted. And the plan is going forward that we do want to keep engaging with government and with other kind of key stakeholders on this issue, because just then going to the responding to the call for evidence and then not actually following up will not be helpful. So we will be following up with government. We are working with other stakeholders in mediation and in broader sort of ADR processes to really sort of look at this and put some research forward as well to support going forward with, if it's going to be a mandated scheme, the things that we've talked about, which we believe need to be in place to make it effective. So that's by way of background. I'll maybe pass over to Isabel just to sort of talk in a little bit more detail, and then I know that Jane very much wants to come in, with that practitioner view. Isabel, do you want to? Thanks. I think you're on mute. In true Zoom style.
There we go. Somebody's got to do it, and why can't it be me? So thank you, Catherine. My name is Isabel Phillips. I am the Assistant Director for ADR and Mediation at the Chartered Institute of Arbitrators. I joined CIArb at the beginning of this year, having spent my career since the mid-90s working in mediation in different contexts, both in the commercial field and also in post-conflict and fragile environments, with some extended time spent in Ethiopia and in former Yugoslavia. And one of the things that I've also been very lucky to do is to spend quite a lot of time with practitioners and working in practitioner environments in a whole range of other countries around the world. And so I have maybe a particular perspective, if you like, on the international non-adversarial use of DR, and some ideas about some lessons about that. But I wanted to start with a question to you guys, and this is what the chat box is for. So I'm going to shut up for just a couple of minutes to let you think and write. What's your definition of mandatory mediation? What is mandatory mediation? Being talked about a lot. I've rarely heard it defined specifically after or before people start talking about it. So I'd really love to see what a few of you think mandatory mediation is. And of course, there's no right or wrong answers here. It's just about getting a sense of what it means to you. And this is one of the joys of Zoom chat. Does anybody take the invitation to participate or not? And how long do we have to wait? I don't know if any of you guys have noticed, but I kind of feel like the whole question of use of silence has changed a lot with Zoom. So the question is, what is mandatory mediation? So is the implied answer that you've come for answers rather than questions? Maybe. Okay, well, if you have got answers to that question and you decide to take me up on it, then I have one answer. So whether you agree or you disagree, mandatory mediation is when the rules of court make it a precondition to the matter being given audience in court. I think disputing parties should first engage in mediation, court-ordered but retaining the right to proceed to court. Mandatory mediation would be the alternative dispute resolution process, leaving litigation as a last resort. So there's some consistency there coming out that it's something to do with requiring people to do mediation or consider mediation at some point before they end up in front of a judge. And some element of compulsion. And I think it's an interesting question because when you start looking across different jurisdictions, what I've really discovered is that there is a huge variation in what's being done. And I think that makes a lot of sense in terms of one of the other things I've observed across the international context. So there's been a tendency, I think, in the last certainly 20, 30 years for the global northern English-speaking jurisdictions to have a tendency to be seen as telling the rest of the world what mediation is. And I think there's now a little bit of a movement, and some of you who maybe went to the mediation symposium, CIArb's mediation symposium, might have been to the panel on hybrid and customary dispute resolution processes, that people from other countries are saying, actually, we've been doing this for a long time, and we do it in different ways, and we do it in complementary ways, as in we use different processes in combination. And one of the critics of compulsory mediation in the UK, Hazel Gunn, actually once said that mediation was, and Tony Allen quoted this again recently, and it's a great quote, that mediation without the shadow of the law is like one hand clapping. And I think what that gets to the core of is that people make decisions about mediating or about using a arbitrative process, an adjudicative process, in view of each other, depending where they are in their conflict and dispute process, and in terms of what alternatives are available to them. So I'm going to share my screen briefly with you, because what I want to show you is something that's in development. So this is hot off the presses, in the sense that it's not even off the press yet, because it's still in development, but it's the result of a process of asking some standardized questions to specialists in different jurisdictions about how mandatory mediation within their particular jurisdiction works. So, for instance, when exactly do you have to do it? What do you mean by having to do it? What's the sanction of doing it or not doing it? When does that kick in? How is that actioned? And what you will see is that there's, within this diagram, quite a bit of variation. So you've got two big pink blocks along the way. One that says file a case, and one which says conclude mediation or forward case to court. So the filing the case, to put that in perspective, some of these systems, you can take your papers to court to file it, and it will be lodged or not, because if you can't prove that you have already gone to mediation in some of these systems, they simply won't allow you to file the case. Whereas in others, they'll take the papers from you, but send you off to a mediation information session. So I've used the term that's used in the family context in the UK, so the mandatory initial session, the mediation information and assessment meeting. So you'll see that Greece has a system where you're sent through a mandatory initial session. You then have to have proof of that in order to file your case. In India, in Singapore High Court, and in Italy, you have to consider or have attempted, and you need to submit proof of that, but there's no system for a mandatory session. So even pre-issue, you've got a lot of variation amongst those few jurisdictions about how it works. Once you add Singapore State Court, which highlights that there's inconsistency in terms of how it's applied even within the same jurisdiction, and Israel, Texas and Ecuador to that, you've got another version of events, as in there's no barrier to you filing a case. And I think I would have to double check again, but my memory is that in all those jurisdictions, you have a responsibility to consider mediation, but you don't have to prove it, which of course is, as I understand it in the UK, you're supposed, of course, particularly if you've got legal advice, to consider mediation, but whether you actually have to do so before you file a case is, as far as I understand, very unlikely. So there's a lot of different options in terms of what mandating even pre-issue means. And of course, once you go post-issue, you've got a whole world of variation. And we've still only really got 6 jurisdictions here, plus the UK that I'm using as the counterexample. So Israel mandates a MIAM after issue. You're automatically funneled into that. And then there's also Kenya, which isn't on this chart yet, which has a screening process post issue, and the registrar decides, as the cases come in written form, whether a very, very small number of exemptions, which specifically are exemptions around things like child abuse and gender-based violence, are exempt, but everything else is forwarded on to a mediation information session. So this raises some really interesting questions, because which has been the tendency, and certainly 10, 15 years ago was very, very hot debate. When was the right time to mediate? There was lots and lots of debate about the right time or the wrong time to mediate. And this highlights how many different decisions you can make. And I think that coming back to this question of what we can learn from jurisdictions like Ethiopia, Rwanda, Kenya, South Africa, India, that have traditional processes, hybrid processes, and flexibly sequenced processes, is that there's probably no one right contingent answer. So if we're looking at this whole issue of mandating, we're looking at how do we make it possible that people can filter into a mediation system at any point that's right in the most efficient way possible. And of course, the other key question of certainly within the normal court process, I was going to stop sharing the screen now. Within the normal court process, it's very normal for there to be sanctions for things like failing to disclose documents, for failing to comply with procedural directions and so on. There seems to clearly be a sort of accepted balance to expecting people to behave in a particular way. And all these systems, even though they mandate in different ways to different strengths, have sanctions of certain sorts, but also enablers of going forward to mediation. And once again, there's a huge variation. So Singapore has set up a set of of judges. They're all judge mediators. They never judge the same case that they mediate, but they are judges. And there's big questions in Singapore around that, given that they are the judge context, and to what extent people are maybe being pressured into settle. And certainly there are concerns, and where there are concerns about that, the actuality becomes parallel to the concerns and has to be carried alongside it. In Israel, there's really interesting questions, because whilst they've set up a separate system with mediators who do everything from the mediation sessions to anybody going forward into mediation, it's a system which requires mediators to report effectively on the behaviour of parties. That, of course, creates some very, very interesting questions about confidentiality. There are other systems in other countries that allow judges to be asking about how parties have conducted each other themselves. So asking one party what the other party has done. So this raises a whole bunch of questions around confidentiality in relation to mandating, and how, if you're going to effectively police whether people are going to A, have participated, and B, how they've behaved within that participation, how you do that without fundamentally changing the dynamics of it. I'm afraid that brings me back round to the same answer, I guess, I keep giving again and again. How do you lower the bar as low as possible, or the pain threshold as low as possible, so that people can enter mediation when they want to? How can you make sure that the information of how to engage is there, and that when they enter it, they're getting what they need from that process, because the people running it are competent and able to do that for them? And that when that happens for different people at different times, it happens effectively, which brings us back to some of the points that Catherine was making around things like funding and cost of mediation, but of course also of legal advice, because front-loading processes like E&E, particularly done by the judge in a case, raises big questions, because you're putting people before an adjudicative process, which is likely to raise the bar in terms of the requirement for legal advice and investment. And therefore, whilst that might not induce further court costs, it could mean that parties are actually having a more onerous cost basis because of the anxiety around legal advice. So there's some really, really interesting, quite complex issues involved here. And where we're hoping to go with the start of the study that we've done so far on that is really some more clarity, and some more clarity about what data we still don't have about these different things. Because what you didn't see in that diagram, of course, is that we make a lot of assertions as mediators around how effective mediation is and how few cases go to enforcement. But if you actually look at what data the MOJ currently gathers, and that is actually accessible, and we simply don't know. And I don't want to disagree. I'm, of course, a huge advocate as a mediator of mediation. But as a researcher, it makes me extremely anxious that we can't actually test that data. And that, again, is somewhere something that we can look to other countries to maybe help us with, who gather their data within their court system in a different way. And that's so that just gives an indication of one of the areas that we're hoping to move into, so that not just we in the UK, but also as CIArb, as a global organisation, can help mediators and court systems and dispute resolution systems, including arbitration, to have a better idea about what the data is actually saying about this, rather than just the assertions of us as mediators that, as far as we know, our cases didn't go forward to enforcement. But do you really know what happened in every case you ever did? Because I certainly don't. So on that note, I'd like to hand over to Jane.
Hey, good evening, everybody. Obviously, I can't see whether I know many people, because I can't see all the names. But for those of you that don't know me, I'm Jane Gunn. I'm the Deputy President now of the Chartered Institute of Arbitrators. I've been a mediator for 25 years this year. So started out as one of the first cohort really in the UK to train as mediator, and to try and encourage people to embrace and experience this new way of resolving conflicts. I've also since lockdown become known as the barefoot mediator, and the reason for that is I wanted to go back and explore the principles, the essence of what mediation is, and I want to talk a little bit about some of that tonight and why that might be important. I'm also a mother and a grandmother known as Bear, and so it's a different spelling for that, and I'm a chocoholic. So I want to look at three issues this evening. One's the principle of self-determination, the second is about engagement and motivation, and the third is about how do we achieve this sort of cultural shift to embrace mediation more widely. There are three benefits, I think, to mediation that we've always extolled, which are cost control and cycle time. It costs less, the parties retain more control than they do if somebody else is making a decision for them, and the cycle time is much shorter. You've not got to go through that long period of litigation. But in commercial mediation, there are some different considerations. So I'm going to start with a story. One of my first mediations, I remember sitting in, and I'd just done, I'd trained as a mediator and I'd practiced my opening statements. I was ready to give my opening statements and giving my opening statement to the parties. And one of the participants in the mediation was just sat back in his chair with his arms folded, with his legs right out, and just staring at the ceiling, and clearly not really engaged in the process, not really engaged with me, and not really, engaged in what I was saying. And that's really interesting to think, well, why is this person not engaged? I believe they've come voluntarily to the mediation, but they're not actually engaged with me and with the process. So there's something else going on here. And I remember in that case exploring with the party to say, what is it? And there was a particular reason behind him not engaging, which was about, I think, his fear of the process, his understanding of it perhaps being more formal than it was. So he hadn't fully understood the mediation process, and my rather formal at that stage introduction wasn't helping. So that was an interesting experience. I trained, and some of you will remember, David Richbell, and he then became my business partner, and we delivered, in fact, mediation training with the Chartered Institute for about 10 years. And David and I had a mnemonic, which was CAVNN, CAVNNN. And C stood for it's confidential, A, you must have authority to settle, and V was this is a voluntary process. And then N was about being neutral and so on. But the V was very important. This is a voluntary process. And so I come back to that always is, are we undermining that very essential principle of mediation being voluntary? And when I trained as a mediator in 1996, there was great excitement, enthusiasm. We thought we'd found this magic process. We could persuade lawyers to adopt it. We could persuade organizations that this was definitely the way to go. Well, I can honestly say 25 years later, it's a long road, and that's okay, but it's taken us much longer than we thought to get lawyers on board, to get the court system on board, but more importantly, to get the end clients on board, understanding the benefits to them of mediating. So it's a collaborative process. We need the court system, we need the lawyers who are often engaged in litigation, but you also need the end client, the business users, to understand and embrace mediation. And I think, as Catherine said, that's one of the last frontiers that we still need to tackle. So I wanted to look then at the point about self-determination. So self-determination, what's important about that for parties in mediation? And I mentioned this sort of process about cost control and cycle time, and that control as being one of the, again, the essential principles that I've started looking back at in my attempt to discover the essence of mediation. So one of the things that's important, or one of the courses I went on after having practiced and trained as a commercial mediator in the facilitative model, was to do transformative mediation. And many people misunderstand transformative mediation, and they think it's a rather sort of psychological process and that we're going to transform parties or transform their approach. But it isn't about that. It's about understanding that at its essence, mediation is a process which enables people to understand where the interaction they're having has gone wrong, where they're unable to effectively have a dialogue with the other party, and to try and make some shifts to make the dialogue itself more effective, more constructive, less destructive, and therefore everybody can participate in informed consent, in being fully self-determining, in making their own decisions, which are not being sort of coerced or determined by a mediator. And I guess that's one of the concerns I would have about judge-led mediation is, are they understanding this process of self-determination and really not interfering in that because of their evaluative mindset, perhaps. And so just to sort of fill you in a bit on that, transformative mediation seeks to make shifts at two levels. One is empowerment. So how can you support, but we would say not supplant, the party's ability to deliberate and decide? So how can they deliberate and decide on their own, but with the support of a mediator? And the second shift then is a shift to what we would call recognition. How can you enable and support, but not force, the parties to better understand the perspective of the other party? One of the things, again, the essential principles I find of the work that I do is that when people are in conflict, they're stuck in this self-absorbed bubble. They can't see beyond that. They don't see what the other parties are trying to tell them. And so the ability to recognize, although not necessarily agree with, where another party is coming from is part of one of those shifts. And when you can achieve empowerment, enabling people to feel fully able to self-determine, and recognition, then you've achieved a shift that enables mediation to work more effectively. And that's certainly something I've experienced quite a lot in my practice. And I wouldn't say I'm a pure transformative mediation practitioner, but I really appreciate those essential principles. The second thing then is about, how do the parties feel in the process? Do they feel heard in this process, or do they feel they're actually on a conveyor belt going along? They're ticking some boxes. And I spoke at the Mediation Symposium earlier this year about party participation and voice, and how I'd done a workshop specifically around that. But it's a really important point to think, if you're going to have a mediation process, do the parties feel, and the lawyers, but as everybody, all participating parties, feel that they have a voice and that they are all fully participating? And I guess, again, that's an essential or an essence of mediation that I would want to make sure that any mandated process or coercive process was ensuring that parties did feel fully participating and fully heard. And there is some interesting research on this. There's a paper by Roselle Whistler, the research director at Lodestar Dispute Resolution Programme. Perhaps I can let Catherine or Isabel have a copy of that. But voice, according to this paper, is associated with parties feeling that the mediation process is fair and legitimate. So it's important, again, that, and maybe my party, who was crossing his arms, hadn't felt at that stage that this was going to be a fair and legitimate process for him. And then party participation is thought to enhance the voice. So, do the parties in mediation, particularly the parties themselves, rather than lawyers, feel that they have an opportunity to say what's important to them and feel that they are heard. So that, that essence of enabling people to have a voice. And that again can be something which is really important role of a mediator, is making sure that often the legal representatives come to mediation and they will articulate the parties' case very much as if perhaps they were in court. But are we enabling parties to have their say in a way that's appropriate to them? And I think, again, that's something I come back to. So at this stage, I just wanted to share just one slide with you, if I can find it here. This is one of the, I've just got to go back to the beginning. There we are. This is one of the principles that I think is really important for me. It's something I call the Falsies of Collaboration, and it's a model that I'll just build out and show you. But one of the things that's really important in terms of the communication that's going on in a mediation are these 4 Cs. Many parties have felt before they've come to mediation disconnected. They felt that they haven't been shown courtesy and respect. There's been perhaps language or behaviour that has separated from that sense of consideration. They haven't felt in control of where things are going, and they haven't felt listened to. So the 4 Cs is about connection. So connection is really about the sense that if in some way the communication or the process is making people feel less than right than the other party, less than respected, less represented, with less, but so many things that make them feel disconnected, then it won't be such an effective and collaborative process. So it's important to ensure that everybody feels that they are respected on an equal level, including parties and lawyers, and that nobody feels less worthy than anybody else in that process, or that they really are being made to feel less right than others. The second point then is about consideration. It is about showing courtesy and respect, and that's a really important part in mediation. And often the language, even the language in lawyers' correspondence has been less than considerate. So it's about establishing that. Control then is so important, as that I've just said. It's really important that the parties themselves feel that they have some element of control in this. And caring is this sense about, do I matter and am I heard? So it comes back again to party voice and participation. So the next thing I want to think about then is the cultural shift. How do you persuade someone? How do you change someone's mind or behavior? Because that's what we're wanting to do. We're thinking here, people are not adopting mediation as quickly as we would have liked. They're not using this system. How do we persuade them? So number one, do you coerce them? Do you mandate something? That's one option. The second one is, do you inform them? Well, we seem to have been doing that for 25 years, giving people more facts and more data, but maybe we haven't been reaching them. And the third option is there somewhere else, or is there something else? And one of the things I think as a mediator that I spend a lot of time helping individuals with is not seeing things the same way, despite the fact that they've been given ultimatums, they've been given lots of information, they're still not changing their mind, whether that's agreeing with another party in a litigation case or adopting some form of behavior that we'd rather they changed to. And one of the reasons for that is what I call the injection theory of communication. If you try to craft the best argument with all the best data and present that to parties, as we know in litigation, it doesn't necessarily change someone's mind. So we have to think, what else is there? And this comes back to, one of the reasons that people behave as they do in organizations, in approaching communication and in understanding how to manage conflict, is because of their culture and conditioning. And that could be the culture of an organization. Is this the way we've always dealt with things? We always pass things on to our legal department. And conditioning. So culture and conditioning are, and one of the things that really spurred me into being a mediator was taking part in 1995, so immediately before I trained as a mediator, in the Tomorrow's Company inquiry, which found then that one of the key things that hold companies back from achieving at their highest level is the adversarial approach to relationships. So if we have embedded in our organizations an adversarial approach to relationships, a litigation culture, an adversarial culture, and that's also part of our social conditioning, we've got a lot to change to enable people to willingly adopt mediation. So how then do we do that apart from mandating? And I can see the argument for mandating, but I can also see some of the drawbacks, as you can hear from what I'm saying, as to some of the things we'd have to get right to enable that to still be what I would call an effective mediation process. So I believe really that actually to enable people to adopt mediation, they've got to consciously choose to do that. It's got to be a choice, it's got to be a commitment, and it does require courage these days because it's possibly still counterculture. So the question that I go back to then is, how do you convince people to change their mind? It's one of the things I want to approach in my presidential year. I very much want to build on the work that Catherine's talking about in reaching out to the business community to better inform them about the benefits of mediation, of ADR, and of what we call EDR, early dispute resolution, really involving them in this dialogue. But the answer is, you can't persuade people, you have to show them. You can't tell them what to do, but you can only show them how the alternative works. And I call this the sort of Harry met Sally moment, as in the movie. You've got to get companies to want to say, I want what they're having. I want my culture in my organization. I want to be able to resolve disputes like other companies. So this means showcasing companies that are doing it well. It means creating some case studies. It means really looking into not just the data, but the stories. How can we show that this really creates more collaborative cultures? It creates a better way of working. It changes that adversarial approach so that companies can truly become highly effective, and they can become tomorrow's company. So I guess that's what I wanted to say. I think we can't force someone to hear the message that they're not ready to receive, but we can plant a seed, and it's the power of planting that seed that's going to help us to achieve this outcome in the longer term. But I'm really looking forward to doing this in my year ahead. Thank you.
Thank you, Jane. Thank you, Isabel. Unfortunately, Ishfaq, who was due to moderate the session, hasn't been able to join us. So I can maybe just sort of step into the moderator role, and I see that we've got a few questions in the Q&A box. If people do want to ask questions, please do put them into the Q&A box, and we'll try and pick them up. So the first question is probably somebody called Ishfaq, but I suspect it might be somebody who's joined using his link. And the question is, hello, can a party to the mediation process turn down the invitation? I'm going to pronounce this because my Latin pronunciation is generally terrible, but limine litis, which my understanding of that, going back to my law school days, is kind of, it means up the threshold. So in other words, kind of at the court steps, just as you're about to embark on the trial. So can you, in other words, put in a motion to and if you do, can the party actually turn down the mediation? I don't know whether Jane or Isabel wants to answer that, but I could give a view, but I'm moderating, so off we go.
I'm trying to find the question again. Was it further back here, Catherine?
It's the first one, and it basically means as I say, I think the literal translation's at the threshold, and it's normally a motion just before the trial begins. as to, you know, and the question is, if you put in a motion just before the trial begins, can the party actually turn down, you know, mediation? Which,
I mean, I think well, I'm going to use the get out clause. Of course, it's going to vary which jurisdiction you're talking about, because that varies wildly. And I'm not a lawyer, so I'm also going to disavow my own views here. But my understanding from the fact that judges, certainly in some contexts in England and Wales, can order you at that point to go off and mediate. They can actually tell you, I'm not going to hear this, go and mediate. And I know that that has happened in the past. I can't quote chapter and verse of which cases. So I think that it really would depend for me in terms of the risk analysis for somebody deciding to turn it down at that point on what they'd done previously. If I would imagine that if the other party had consistently up to that point refused to mediate and then suddenly says on the court steps, oh, can we mediate now? And that the party who's been trying to get a mediation to happen might at that point be reasonably able to turn it down and justify it to the judge on the basis that they got that far. But it would depend on I would assume, on how good the evidence was that they had been trying up to that point to mediate, because there is a reasonable, there's quite a balancing act, is my understanding, once you get before a judge in terms of your behaviour up to that point around ADR. So I would think it would depend a lot on what the evidence was around that, how that would be treated, and what the risks as being the person turning it down was taking in terms of their previous behaviour. But I defer to my learned colleagues here who actually are lawyers, and particularly, so.
I don't know, Jane, if you wanted to come in, or...
And I don't think I have anything specific to add to what Isabel said. I think, again, you know, depending if this comes in, or in countries where it does apply, it depends what the criteria are and whether people are, you know, within the criteria at the time that they choose or choose not to adopt mediation or follow through with it. And I think that's going to be one of the critical questions, is how do you define the criteria so that it's clear and that it's fair as to how people make their choice.
And I think that's right. I mean, I think, you know, obviously the Cjc report looked at the issue of Halsey, but it hasn't overturned Halsey. And so, you know, the sort of legal principle that Halsey is still good law until it's overturned. But obviously, there's a, you know, fairly sort of strong recommendation from the CJC that may happen in due course, because, you know, you've got Article 6, which obviously has been interpreted in a way that suggests that, you know, a kind of, you've got the right to go to court, and therefore, you know, sort of forcing somebody down a mediation route which would avoid that could be problematic. So, you know, and I think that's you know, clearly been, you know, what we talked about at the beginning of one of those legal blockers. But I think it's an interesting issue when it goes to the question of costs and, you know, conduct of the parties. And there's obviously other mechanisms in litigation which could result in, you know, certainly a party in that position being penalised. Would be my sort of off the top of my head answer to that question. But I'm supposed to be moderating, so let's move on to the next question. So the next question is from Polyvoios. I do apologise if I've mispronounced your name. What questions do the interested parties need to ask themselves when deciding on the ADR to be followed, and what would be the key pros and cons of mediation, be it against adjudication? I don't know, Jane, Isabel, anybody?
Well, I think, again, it comes back to this question. I mean, it was one of the first questions we've always been asked, and again, many organisations don't fully understand what the term ADR means and what the difference between mediation, adjudication and arbitration is. You know, we've had to explain that, and I still get asked that. So there is a misunderstanding or a misconception about what those different terms mean. And therefore explaining specifically and particularly the difference that mediation has to an adjudicated process where, you know, the parties are not making their own decision is really important. And I think, you know, obviously there are pros and cons there, but I think it's that that essential, do you want someone else to decide for you based on, this process and your evidence, or do you want to be a participant in a dialogue where you collaboratively decide, or you decide, yourself what the outcome is? And that's the most important distinction there that, as I say, many businesses still don't understand.
And I think that that's also a language problem in part, because we refer to adjudicative processes as a group of processes where the third party is making a decision, which
Yes.
of course is something separate from adjudication as a specific process, which is furtherly unhelpfully used in different ways, again, in different jurisdictions. So in England and Wales, adjudication is used in a fairly limited set of quite specific circumstances and has quite a few specificities, but they don't travel well. So if you go to other jurisdictions, it can be somewhat different. So adjudication, as used in England and Wales, is usually an obvious choice because it's in a contract that it is the thing to use. And it means that it's an adjudicator producing often an interim decision, particularly in the construction context, that allows work to continue and may or may not be rolled forward into an arbitration at the conclusion of a construction contract. So it's quite a specific thing. There are other adjudication contexts in England and Wales, but that's one of them. Whereas mediation is something which, of course, people will now sometimes be in effect forced to use by the contractual obligation that they've signed up to with the other side. If it says in the contract, in the event of a dispute, you need to mediate, or you need to consider mediation. Of course, that has different implications. So the first point is the contract point. What is the contract or contractual context you're working in telling you that you have got to consider or you've got to do? But outside that, it's for me clearly around the question of control. Do you want to retain control, or what's decided about what happens in this situation, or are you actually fed up to the back teeth with it and you just want somebody else to decide for you? But if you just want somebody else to decide for you, you don't really want to go to mediation, because that's not where you want to be. And this is what I was talking about this balancing act of what's important to you, at which point, and that different parties end up at that point, that fed up to the back teeth and just decide, I don't care if I lose, I don't care if I win. I think actually the problem with that is people get thinking they're at that point, and then when they get the judgment against them, they don't go down on one knee and go, thank goodness I've got a resolution, and oh, I was wrong. It tends to end up panning out slightly differently. But I think those are a couple of the key things around that, and that for me is that really, if you've got a free choice because there's nothing contractually binding you to something, it's really about that question: do you want somebody else to decide, or do you want to retain control of the impact that it's going to have personally, commercially, and potentially legally, if that's part of the equation?
Thanks, Isabel. I mean, and just as a sort of a segue, I think the next question is really about those sort of contractual terms, and I believe it's from Adeyemi, but masquerading still as Ishfaq. The parties usually accept mediation with a bit of hesitation, especially when there are express terms in the contract with relief for any breach. However, in mediation, the party will seek to negotiate this away this provision. How can we address the issue of fairness in mediation? And I think probably the question is really getting at that sort of negotiating the terms away, be it at the time when the contract is being agreed, or indeed sort of thereafter as part of a mediation. I don't know if any of you got any thoughts on that issue.
I'm not sure really. I guess it's down to what people, I think at every stage, if you've got something in a contract, at every stage you've got to do something clearly, haven't you, with a clear understanding of what this stage of the process means and what you're agreeing to. So, whether that's accepting a clause in a contract and what that actually means. I think many times people may sign contracts with clauses for adjudication or arbitration or mediation without understanding what that process would look like and what they're actually agreeing to. So I think, again, there's a gap there in terms of helping people to understand what the process itself would look like and how you then are agreeing to that and what you're agreeing to. And at each stage you've got to make sure there is clarity, I suppose, about what people are agreeing to and whether they're happy with it, because that's part of the consent process as far as I'm concerned.
Yeah, I mean, I think that's absolutely right, Joan. I mean, in its purest form, all a contract is a sort of the script of what the parties have actually agreed, and therefore, if you've got a situation where one of the parties doesn't want a provision surrounding ADR, then obviously you can test that and test their thinking to see if they really understand what the consequences of that is. But if they are clear about what that term means, then it's a question of whether that falls away as part of the negotiated process when you're agreeing the contract, or whether actually it's one of the points that becomes a sticking point for the principle, and and then becomes part of that sort of bigger negotiation around what the contract should look like. So I think it does go very strongly to this point about understanding what is in your contract and what you are actually signing up to and what you're agreeing to, which goes to this point about having a better understanding of what ADR is and how it can actually benefit business and business certainty and certainty of the parties, and can deal with disputes hopefully quicker and perhaps more cost effectively. And so I think that's the key, and I mean, I think it also goes part, Jane, to one of the points that you were making about sort of one of the one of the challenges with some of the ADR processes can actually be the lawyers, in the sense of how they advise their parties and their perception of the use of ADR. And and I don't know if you've had any, I mean, obviously you've been trying to deal with this for the last 25 years, as has Isabel as well. And I just wondered if you've got any thoughts on how do we get some of the lawyers that are perhaps, we've got some lawyers out there that fully embrace this, but we've also got some lawyers that can be quite hesitant. And is there anything more that we can be doing to espouse the benefits of ADR with the lawyers and get them on board?
I do think it's the same thing. And we have started, obviously, bringing in a training for lawyers to understand. I mean, personally, as a mediator, I would spend quite a bit of time pre-mediation talking with lawyers about how it could be helpful for them to approach a mediation day. Specifically, this is an opportunity for dialogue, not for war. It really is. You don't rehearse. This isn't a rehearsal for your court case. This is a collaborative, dialogue-based process, and help them at that stage, if they're willing, to understand how they can best use that process and me. And many of them will respond to that. I did in fact, I was hired recently to do just not the mediation, the pre-mediation process with somebody who wanted to, with the lawyer and party. And what was brilliant is they ended up crafting, instead of their legal position to be regurgitated in mediation, their story. They ended up telling a story with slides and video about this particular construction project, in actual fact. And it was so much more powerful than, and the lawyer said to the client, you tell the story, I won't tell the story, it's for you. And I thought that's a much better approach, which is not fully understood sometimes, but it's it's that and that's again one of the key essential differences and essences of mediation.
Yeah, thank you, Jane. I think that is it on the questions. I think I've just had a quick look through the chat and I can't see any other questions. So maybe we could just sort of finish with a couple of final thoughts from our sort of panelists. I don't know, Isabel, if you've got any final thoughts on the subject matter.
I think I just would add that I think that the people that really we need to work with more are the people who we don't ever get as far as the pre-mediation calls with, and the question of how we access those people and how incentive can be used as well as the cudgel to encourage people to engage with mediation. So in my experience, people like general counsel and in-house legal teams can often make a very big difference to what happens, because these incentives are different and because the commercial realities are closer. So I wonder if, as a mediation community, if we are such a thing, that's the sort of place that we should be looking at more, and less from the perspective of why we think mediation is so great, because that's, to be honest, not the thing that people usually ask about. I sometimes think we're maybe answering a question we're not actually being asked. We're answering the question, is mediation great? And we're saying yes, 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 when actually the questions are much more like the ones that we've had today about how is this actually going to work for me? How can I make it work for me? How does it differ from the adjudicative? So I think we need to listen a little bit more as mediators to what we're actually being asked, and start answering those questions rather than following a script that, as Jen and I know well, you can tell people as much as you like how great it is, but that doesn't actually seem to be the principal change agent.
Thanks. So more active listening then from the media. The irony. Jane, your final thoughts.
Yes, I mean, I just think I echo what Isabel says, what you started off with, Catherine. I think, and I look forward really so much to my year as president in being able to really work with, the end users of mediation, and really, try to help now embed this change of approach, this culture change, and understanding better how we can do that. So if anybody's got ideas on that, that's going to be my piece of work for next year.
Yeah. Thanks, Jane, and we're really looking forward to you starting your presidential year. I think it's going to be fantastic, and fantastic to have a mediator as the president of CIArb. So thank you everyone for joining us tonight. I'm so sorry that Ishfaq couldn't be with us. I hope you found it useful. We have recorded it, so hopefully that will be available. I'm sure the team will sort that out. And and if you do have any thoughts after the presentation, you want to get in touch, then please do reach out to us, and it'll be great to have your views, and we'll keep engaging, we'll keep discussing this issue with governments and with other stakeholders, and let's see where we get to. But we know that the call for evidence is certainly not the end of the journey, or let's hope it isn't anyway. So thanks everyone, and have a great evening.
Thank you.
Thanks. Bye.
Thanks very much. Bye.
Bye.